नमस्कार. आयच्या या खासा हेडोनात तुमकां सगळ्यांक येवकार. मायनिंगाची ऑर्डिनन्स आयली आनी ताजे उपरांत खूब जाण म्हणपाक लागले की हातूंत भितर थोडी ग्रे एरियाज आसात, सगळेंच ब्लॅक एंड व्हाईट ना. तर जो मनीस हे ग्रे एरियाज काडून आमकां क्लॅरिटी दिवपाक शकता ते आज आमचे बरोबर आसात आयच्या इंटरव्यूआ भितर, आनी ते म्हळ्यार गोंयचे ॲडव्होकेट जनरल आत्माराम बाब नाडकर्णी. स्वागत तुमचें. तर तुम्ही ऑर्डिनन्स पयली, what is your first reaction? Are there gray areas or you have deciphered all the gray areas by now?
See, in every law which is made, there could always be a gray area, okay? Now, ingenuities of this profession are not unknown. So every lawyer can, with his spark, always come out with some new proposition of law and challenge a provision. But insofar as the present ordinance is concerned, it is made with a particular purpose. The purpose is the period of lease is specified. At the end of the period of the lease, there will be auction. That is the main purpose insofar as Section 8 and 8A is concerned. There are other sections which deal with setting up of special courts, etc. for trial of offences. Those are different things.
तुमकां कितें दिसता जेन्ना लिजाची रिन्युअल आनी लिजाचो पिरियड ह्यो दोन गजाली आमी पळयतात, वॉट इज द क्लियर कट मेसेज कमिंग आउट ऑफ दिस ऑर्डिनन्स? म्हणजे ज्यो रिन्यू केल्यात त्यो गोंयच्यो लिजो आनी ज्यो रिन्यू जाली नात त्यो हांकां तुमी कशें पळयतात आतां आफ्टर द ऑर्डिनन्स?
Those which are granted, lease is granted, will be for a period of 50 years. So 50 वर्सां तांकां. पयलीं 30 वर्सां, मागीर 20 वर्सां. That is a provision. So in all they get 50 years.
Correct.
Okay. गोंयच्यो ज्यो पळय आज पर्यंत ज्यो पळय रिन्यू केल्या, that is granted for a period of 20 years. That will go till 2027 because that grant is from 2007 onwards.
Correct.
Now, if you see carefully the provisions of this act, it says that it will not apply. One subsection clearly says it will not apply to renewal applications pending on the date of the commencement of the ordinance, but not rejected.
So what happens to those?
So in other words, if there are pending applications, would they not be covered? Well, that's plain and simple English. There's no need to confuse. I mean, if you have a conceptual clarity, you simply read it, read the provision of law and apply.
So those leases will go for auction?
Not necessarily. Which leases?
Those which are pending application.
Those which are rejected will go for auction, right?
Those which are pending.
Those which are pending. Now, pending but not rejected.
Correct.
And if they are granted tomorrow, the power to grant has not been taken away. Because once you have made an application for renewal, that is the right which you have gained to get your application decided pursuant to the law. Thirdly, there is a High Court judgment also there. There is a Supreme Court judgment also there. Their main petition is pending in Supreme Court and all. So if at all the government of India wanted to say that they could have simply abolished all these leases, they could have straight said that forget about all the renewals, etc., go for auction for that is a possible thing. In fact, I had recommended to the state government that you auction out all the leases after the Supreme Court judgment. But unless the law clearly says that, is the law so clear on it that all the leases have to be put on auction? That can't be. So you'll have to go through, you'll have to see the facts of each case and then apply the legal provisions to that.
But सद्याक जी पेंडिंग आसा तांची भवितव्य कितें?
Pending asat, those have to be decided. Government can reject them. If they are rejected, they'll have to go for auction.
And if they are renewed, they are valid till 2027.
If they are renewed as of 2007.
The second thing, the date that comes in the figures in this notification is 31st March 2020. ही डेट खंयची क्लॉजा खातीर अप्लाय?
31st March
2020. ते म्हणतात की where mineral is used for other than captive purpose shall be extended and be deemed to have been extended up to a period ending 31st March.
That's earlier, that in the draft it was 5 years. Now it is 31st
with effect
March
from the date of expiry of the period of renewal last made. So ही कोणाक लागता? ही 31st March 2020 ही डेट कोणाक लागता? गोंयच्या लिजाक लागता?
Those which renewals which fall between today and 31st March 2020. For them, that date will apply.
So आता हाजे मुखार जर रिन्यूअल जालें जाल्यार ती 2020 मेरेनच आसतली.
Now, not necessarily. if the renewal takes place today, then the period of renewal. If the renewal takes, suppose the renewal insofar as Goa Mines is concerned is as of 2007.
Correct.
It is not today's renewal.
Correct.
All of them had applied well within time. That is what the Supreme Court also says. That is what the High Court judgment is. Okay. Now that matter is pending in Supreme Court. So Supreme Court will give a finality to it. But that does not mean that this 2020 period will apply to some of them, will not apply to others. That is not how. If you see the provisions of 2020, it uses the word whichever is later.
Correct.
So if that is so, obviously if the period of renewal goes beyond that, it will go beyond.
So it will be 2027. तिसरो जो मुद्दा आता तो तुम्ही 50 yearsचा म्हणिल्लो which says that from the grant of lease
30 plus 20.
30 plus 20 50 ग्रांट ऑफ लीज खंयची डेटीक सोन आमी धरपाचे कारण कांय जाण आर्ग्युमेंट घालतात की तुम्ही कन्सेशन्स एबॉलिश केली 1987 आणि तुम्ही ग्रांट मुडी इन 1987 so that grant should be considered from 1987 and 50 years from there which will extend to 2037. How are you looking at this grant
No, I'm not.
concept?
See, everybody is free to argue.
Yeah. But what is the state's interpretation?
What has the Abolition Act done? Abolition Act has abolished the mining concessions which were held by the concessionaires. At the same time, the Abolition Act has said that all these leases will be deemed to be mining leases from the appointed date. The appointed date is 20th of December 1961, right? So the grant goes back to 20th of December 1961. But from 61 to 87, there is a deemed fiction which is done. And they have said, notwithstanding that period, etc., they have said in 87, that is within 6 months from the date of coming into force of the Concession Abolition Act, they will be renewed. Supreme Court has held in the Goa Mining Association judgment that that is the first renewal. So if that is the first renewal, will you call the first renewal a grant?
So 87 is the first renewal in clear.
87 is the first renewal. It is not a first grant.
So this 50 years clause गोंयांतल्याच वर्षा लिजाक applicable जायना.
Obviously not. Even if you apply it, you will have to apply from 61.
So 50 years have lapsed.
Therefore, all those things are there.
Okay. दुसरी गजाल आहा ती making this a cognizable offence. 5 years imprisonment and 5 lakh per hectare fine. गोंया भितर जो गोंधळ जालो जितली सरकारान केसीस फायल केले on that backdrop how are you looking at that provision?
See, the first principle of law is, and it's a Latin maxim, nullum poena sine lege, nullum criminal sine lege. That means an act which was not an offense on the date it was committed can never be punished thereafter. See, today if, say, eating a bread is an offense, and you make it an offense today, that if you eat a bread, it is a prohibited substance, it's an offense. You can't be punished for eating bread yesterday. So whatever criminal law amendment is done, in case of civil law, it is different. In case of taxation, it could be retrospective. It could be, in case of fiscal law, it can always be retrospective. But in case of criminal law, it is never retrospective. It can never be done with retrospectivity.
So to me, what you are essentially
so therefore, this 5 lakhs and all those provisions do not apply insofar as those illegalities by the which happened in Goa are concerned. But nonetheless, if there are irregularities which are covered by Prevention of Corruption Act, Indian Penal Code, Minerals and Metals, Mines and Minerals Regulation and Development Act, those offences remain. So it may not be 5 years or whatever it is, but those.
But what you are basically saying is, जो केसी गोंय सरकारान हाजी पयली इल्लीगल मायनिंगा खातीर घाल्यात, त्यो ह्या एक्टा अंडर कॉग्निजेबल ऑफेन्सेस जावची ना.
For the action committed in the past. But if they commit anything that is after the ordinance.
After the ordinance, समजा गोवा सरकारान एक केस घाली इल्लीगल मायनिंगाची.
केस घालपाची न्ही. On the date when the offense act is committed. Case केन्नाय घालूयात तुज्या. Within that limitation period, you can always file a case. But for any offense which has taken place in 2007, till the date of coming into this effect of this ordinance, that is not covered by this ordinance.
What about the special code? कितलो फायदो जातलो आणि खरे स्पीड अप
Special
जातलो काय ना?
code will only speed up matters. When you appoint special court, you appoint a dedicated court. So that will help. Special courts like corruption cases, it has helped in those cases. So special courts is one of the provisions which is now seen.
सेम ज्यो केसी गोंया भितर घाल्यात त्यो ह्या कोर्टा अंडर येवपाक शकता आता.
It will go before those courts.
It will go before those court. Only thing is that as far as the punishment is concerned, that will not be covered as per this ordinance.
Special court will have the jurisdiction. It will be like any other ordinary court. But only thing it will be designated. Like for example, Sessions tribal case. CBI court, special court was also one of the session judges. So this will be one of the magistrate or session judges depending upon the qualification of the judge.
दुसरे आता डिस्ट्रिक्ट मिनरल फाउंडेशन तांणी प्रपोज केला. कशें आसतलें फंक्शन या डिस्ट्रिक्ट मिनरल फाउंडेशनाचे आणि मॉडेलिटीज कशी असतली आणि सगळ्यात चड फायदो कोणाक जातलो?
See, if you see now the Supreme Court says have a permanent iron ore fund. Then there's a district mineral foundation. These are basically towards corporate social responsibility. ज्या पळय contributions जातले. All these funds will go to them. This district mineral foundation, they will decide. But there will be some people who will be deciding as to what is to be done with the village. Sometimes the village is affected, sometimes an area is affected, sometimes certain communities are affected. So all that will be
basically district mineral foundation भितर जो fund वतलो that will be spent for that particular mineral belt.
correct.
That will not be spent elsewhere.
It has to be spent for development of that particular mineral belt because that belt is the affected belt, but not necessarily. For example, you will do mining in Sange Taluka, in Kurpem area of Sange Taluka. Okay, you are taking the ore and doing loading at Savade. So there may be people affected by mining Savade also, the jetty, the plot, etc. So you have to find out where it is, not necessarily where the mine.
पण फाल्यां तो पयसो काढून मडगांव किंवा ताळगांव किंवा पणजी घालपाक मेळचो ना. तो त्याच बेल्टा भितर स्पेंड करचो पडटा.
Obviously, it is meant for that particular spend.
ओके. दुसरे आता नॅशनल मिनरल एक्सप्लोरेशन ट्रस्ट जे परत थंय हें केला. एक मायनर्सांचो आर्ग्युमेंट आसता की आमचेर तुमी आनी कितलो म्हूण भार घालतले. तुमी एक्सपोर्ट ड्युटी घाल्यार रॉयल्टी आसा. वेल्यान आतां 10% परमनंट फंड आसा आनी हें आसा डिस्ट्रिक्ट मिनरल फाउंडेशनाचें विच इज 1/3 ऑफ द रॉयल्टी. तुमकां कितें दिसता वेन यू एनालायज बिकॉज यू हॅव गॉन टू दी deep roots of this entire business? Are we taxing the industry too much or it is justifiable?
See, that is a good question. One is, no industry should be taxed too much. It is bad taxation if you tax the industry too much because that industry has to survive. But at the same time, when you do some business and especially when you deal with natural resources, every sector, every participating head must come out with a fair deal of profit. Okay? Now, when they extract this particular iron ore, they pay royalty. They are required to pay 10% towards the permanent fund. They are required to set off something towards corporate social responsibility. They have to also pay other taxes, etc.
Export duty also.
Export duty. They have to consider all this and price their commodity. Now, it is true, when they price their commodity, it is possible that when you say, today my per so much, per whatever ton, etc., it's X number of dollars. And if China gets the same thing from Australia for a lesser amount, obviously the Australian market will benefit. Our market would benefit. So therefore, when you decide, when the government decides to tax, it has to have the macro view in mind.